Our three branches of government, executive, legislative, and judicial, administer our democratic, civil, and legal rights. Since 1905, the California Courts of Appeal, as the intermediate courts of review, have ensured that the law is interpreted and applied consistently and uniformly in the trial courts. During their long history, the Courts of Appeal have presided over the expansion of legal theories and have set volumes of precedent, producing a body of law that protects the rights of all Californians while advancing the administration of justice. Beyond the bench and the black robes, the justices are ordinary people, women and men from diverse ethnic, cultural, and economic backgrounds. Their personal stories and reflections shed light on how the law is shaped and what motivates individuals to embrace a career in the law. Here are some excerpts from the California Appellate Court Legacy Project Archive of interviews with retired state justices about their life experiences, the work of the court, significant cases, judicial philosophy, and how the institution and the law have changed over time.
The high school, though, Los Banos High, when I graduated in '61, had 400 students. My class was 89. About 7 of us went to college. But we had a good time. We did things that kids in small towns did in those days. Dragging the mane was a popular pursuit. What's the name of that movie? American Graffiti. If you see American Graffiti, you see my life.
I would get a book and I would read books. And as my mom would say, I would bury my face in a book and I would just ignore everything else.
That was your way of adjusting.
That was my method of adjustment, yeah. Very effective. Kind of like working on the Court of Appeal.
I remember watching the civil rights movement on black and white TV and the Montgomery March and Martin Luther King and you know, and
in your neighborhood.
Yeah, the Watts riots were right in my neighborhood. My dad was on LAPD at that time, and I can remember we lived in kind of in a hilly area, and I can remember looking out our window and seeing LA burning, and not being able to cross Crenshaw because that was the curfew line.
I worked during the day, juggled the kids. They were all, let's see, they were about 10, 11, 12. They were all very close together at that point. And went to law school 3 nights a week, 12 months a year for 4 years.
After 22 years of private practice, becoming a judge was a wonderful change. I think I'm probably alive today because I became a judge and could enjoy what I was doing so much.
Being a judge isn't, practicing law isn't like going to the garage and taking the bicycle that you haven't ridden in several years and just pedal down the driveway. You've got to be up on the law, you have to be current on what the rules are, and you have to be in control.
The chief talent of a good attorney is being a quick study, certainly a good appellate attorney. And it is very definitely the talent of a good judge is to be a quick study, and so I tried to achieve that by going to the sources, learning what you have to learn, and learning from the lawyers.
I enjoyed oral argument, and I found that oral argument really affected the way I voted on a number of cases, and also affected the final product.
You've got to carve up a case into its important parts and discard the rest of it and then write about what's significant in an intelligent way so that when someone reads it, they know what the case is about and they know why you decided the way it is.
And we had a wonderful, vigorous discussion amongst us, which was, again, something on the Court of Appeal I really loved. We had, if we were undecided on something or we had some differences, it was wonderful having those discussions. They were never heated. They were never ones where anybody walked away mad or wasn't talking. Or it was just a wonderful experience to engage in those kinds of discussions. I thought in many ways it was the best part of the job.
I did have the first DNA case in Alameda County, People versus Barney, and we had a lengthy hearing, Kelly Fry hearing before the trial on that one. The interesting thing about Barney was that the DNA evidence wasn't dispositive. Mr. Barney dropped his wallet at the scene.
Here I am appointed to the Court of Appeal, and immediately I am put on the panel for the Manson cases and the Onion Field case. So I had to get in and bone up on my law that I had learned in criminal law.
Boken versus Philip Morris, which was involving a person that died during trial from smoking cigarettes because of cancer. It was the first Southern California case where a multi-billion-dollar award was made against Philip Morris for fraud, $3 billion, in fact, for punitive damages. And the reason that was so significant in my mind is that that gave the factual background of what had happened since the early 1950s, all the way up to the present with regard to how tobacco companies package their product, advertise their product, and if you ever read the decision, you'll find out that we upheld the jury's verdict for fraud.
Rosencrantz was a murderer who killed a kid when he was 18, killed his buddy's boyfriend for outing him to his father. He is gay. And it was a terrible crime. There's no two ways about it. It was a horrendous crime. He was sentenced to 25 years to life. And the parole board kept denying parole and kept denying parole on a record that suggested that they were denying parole in large part because he was gay. The parole board was transforming a sentence of life with the possibility of parole into a sentence of life without the possibility of parole. And I think that was a place where judicial intervention was warranted to see that a fairness principle was imposed throughout this process. And I do think that it is up to the parole boards to make these decisions and not to the courts. But I do think that the court's involvement is necessary to make sure that the parole board and the governor is playing by the rules.
But on the Superior Court, when I first joined it, one woman, very, very talented person, and she didn't get a lot of help, let's put it that way.
Mm-hmm. You know, and you look back, and I've sort of studied the history of, you know, like African-American judges, and until the 70s, there were so few. You know, maybe one a decade almost. You know, that Edwin Jefferson and Bernard Jefferson, a couple of the early ones, and then it was, you know, just so few for so long.
In my remarks, I commented on the fact that, I was being nasty really, but I commented on the fact that it was a privilege to be in the athletic club because the only way I could get in there was as a guest of someone else. And they were asking me about, you know, the bar, and I said, well, that the usual quota had been imposed, and there were 3 persons who had passed the bar, but that I hoped that, you know, that was something that was going to be corrected in the future.
That I had the advantage. I mean, it was so new to be a woman. The juries just were enthralled, and the judges at the municipal court level seemed to be very taken by having women in their courtrooms for the first time, and very respectful. When I got to Superior Court, some of the older judges, I think, took a dimmer view of it. But again, even with the juries, there was never a doubt. I felt that I had the advantage, and the guys didn't know what to do with me. I mean, I weighed about 95 pounds in those days, and they couldn't beat up on me like they would their male opponents. And so they were kind of, you know, fumbling around for how to handle this new person in the courtroom.
I had a judge call me little girl. I had bailiff tell me you can't come in here, you know, where the bar was, because he assumed I was not a lawyer, and that kind of thing. But it was more a basis of ignorance than anything. You know. I remember the first time my law firm sent me to argue a case of any substance, and afterwards, one of the partners knew this judge, so he asked him afterwards, you know, what'd you think about her and everything? He says, I didn't hear a word she says, but she has beautiful hands.
Each judge knows that they're there to do only one thing, and that is to analyze the case that they have before them at the time or the cases, see if the law was correctly applied, and look at it from that standpoint, and not look at it from any type of a political standpoint.
Everyone that comes into my court has the same status, and that in terms of the respect that they're warranted out of the box. So if it's a pro per, you know, a homeless person, you know, a police officer, you know, a very prominent lawyer, I mean, the homeless guy is going to get respect from me just like the prominent lawyer.
This is a society, ours, that's held together by certainly not by race. We're incredibly diverse, not by religion, not even by language anymore. It's held together by the uncommon boast that we are a people, and it's a boast and a claim laid out in our constitutive law, the Constitution. It's a republic of a concept of ideas.
I'm very concerned at the Supreme Court level with this debate that's going on as whether or not you should humanize the judiciary. And I wouldn't want to be in a country where there wasn't an element of humanization of the judiciary. It doesn't mean that you're going to abort your knowledge of the law or your commitment to following the law, but the fact that you're human enough to say separate but equal isn't equal is not a distortion of the law, and there's so many facets of our society that wouldn't make any advance at all if it weren't for judges that first of all recognize the problems and then were willing to address them.
Those decisions were supremely important to the people involved in them. It was very likely, unless it was a big corporate case, that was one of the most significant events of the lives of the people who were involved in those cases.
Judges take an oath to defend the Constitution and apply the law of the state. That's their job. And personal beliefs or concerns have to be set aside.
More than anything, I wanted to get it right.
We are grateful for the candor and perspectives of the justices who participated in these interviews. Most of all, we appreciate their public service to the courts and the people of California. We hope their stories will inform, educate, and inspire.